Please, Your Lordship. Your Lordship, I beg to mention item number 12. Connecting counsel is indisposed, Your Lordship.
On premier with the appellant, this is matter to 2 weeks.
Duly obliged, Lordship. Please, Lordship. I beg to mention item number 4, Lordship. Kindly list this matter up to 2 weeks, Lordship.
Why?
The arguing counsel is having personal difficulties, Lordship. The arguing counsel is having personal difficulties here, Lordship.
Oh, this is a petition.
Criminal repetition, Your Lordship.
On pre-made by the petitioner, or pre-made by Mr. Letter counsel for the petitioner. Not objected to by Mr. Counsel for appearing for the respondents. Matter is adjourned. This is up to 2 weeks.
Hello, blush. May it please, Your Lordship. Lordship, I beg to make a mention of item number 3, Your Lordship. Your Lordship, I brief this matter may be taken up after 2 weeks, Your Lordship.
What is this matter about?
Your Lordship,
This matter pertains to the these people are working in the Assam Rifle Department. They are seeking parity with other forces, Your Lordship, with regard to their pay scale. So this matter is perhaps, Lordship, it was disposed by Honorable Cat. They have challenged that order, Lordship.
Oh, okay.
There's a direction against them to comply to that order, so they have challenged that order.
But why are some Rifle matters coming before CAT?
No, because the repetition, any order passed by the Honorable Cat will be.
No, that is true. I'm saying why the petition or the parties concerned. Or
These are ministerial departments, not officers.
More often than not, we see service matters involving some rifle personnel are filed before the High Court.
No, these are ministerial office.
Ministerial.
Lodge.
There's a difference between ministerial employees and
Because these are not military personnel, Your Lordship.
D3 matter. How long?
Your Lordship, 2 weeks, Lordship.
I can do that one framed by the Lieutenant Counsel for the petitioner. I think this is matter 2 weeks.
This item 16 as well, Lordship. 16. Can come after 2 weeks, Your Lordship.
It's a joint prayer, Lordship. It's a joint prayer, Lordship.
This is also a CAT matter, Lordship.
Last time your senior colleague was pressing so much for this matter, now.
This is, in fact, the respondent has expired, Your Lordship. During the penancy, there's a substitution. His wife is represented now. This is a service benefit matter, Lordship.
So this is a joint prayer.
Yes, Lordship.
On joint prayer made by the parties. Matters adjourned. This is after 3 weeks.
Much Lordship.
Yes, Lordship. I beg to make mention item 13, Your Lordship. Lordship, in this matter, we are newly engaged in this matter. So we bring for 3 weeks time, Your Lordship. 13, Your Lordship. We are newly engaged in this matter.
Welcome, Thongni.
Let the matter be called up.
Let it be called.
You've been recently engaged.
Your Lordship.
Your engagement has to be taken on board.
Lordship.
You have filed your power.
No, Your Lordship. We'll be filing, Your Lordship.
Let the matter be called up and pass the orders.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 14, Lordship. I'm framed for 3 weeks' time, Lordship.
14. On pre-made by the appellant, this is matter of 3 weeks.
Lordship, similar prayer for item number 15, Lordship.
Same case.
No, Lordship, different matter, Lordship.
Huh?
It's an appeal, Lordship, POXO appeal, Lordship. Item number 15.
From the same
No, Lordship.
14, 15, not connected.
Not connected, Lordship.
Same lawyer only.
I get to pre-made by appellant. This is matter after 3 weeks. To go into 3 weeks more.
Please, Your Lordships. Your Lordships, I beg to mention item number 6. Your Lordship, the conducting counsel is indisposed, Your Lordship. Your Lordship, I pray that the matter may come up after 2 weeks.
No objection, Lordship.
On pre-made by Mr. Then counsel to the appellant. This is matter after 2 weeks.
Obliged, Your Lordships.
Lordship, I beg to mention item number 8 and 9, my lord. I'm praying for 2 weeks' time.
Item 18,
8 and 9.
8 and 9.
Yes, my lord. My lord, written argument has been filed, my lord.
Different argument.
Yes, my
That
lord.
has been heard.
Hearing by it's almost, my lord. Only is on some point, my lord. We have submitted the written argument. Now only oral is left.
We have not concluded our part, my lord. We are supposed to reply on that, and because the petitioner chose to file a written argument, and
Oh, okay.
Oral is left, my lord.
They filed a written argument and a matter to be heard.
Yes, my
matter
lord.
to be heard from on the part of the respondents, my lord.
Responded. That's what it is. Mr. Learned Counsel appearing on behalf of Mr. M. Sharma, Learned Legal Aid Counsel, has sought for accommodation on the ground that the said Learned Legal Aid Counsel is indisposed. The same not be objected to by Mr. S. and Gupta, Learned Additional PP, that is adjourned. This is after 3 weeks. 7 and 8.
8 and 9, my lord.
Practically we have nothing.
May it please, Lordship. Item number 7 and 10, Lordship. Mr. Arguru is appearing.
Yeah, practically we have nothing to. What are we sitting here for?
No, Lordship, Mr. Guru is the conducting counsel in this matter. He is on leave. 7 and 10, Lordship. He is on sanction leave, Lordship.
Mr. As far as this 10 is concerned, you have finished your.
Yes, Lordship, finished. Only written synopsis also filed. It is from the state only.
Only the state is to file the written synopsis. 1 week time?
Only for filing.
Yes.
Argument complete.
Argument complete, Lordship.
Only to file the written synopsis, Lordship.
On pre-made by Mr. H. Karmi, Learned Additional PP, has sought for accommodation on behalf of Mr. R. Guru, Learned GA, who is conducting the matter, as said, Learned GA is indisposed. The prayer not be objected to by Mr. SD Padia, Learned Legal Aid Counsel, that is adjourned. This is after 2 weeks. This is
For item number 10, this is.
10. But
I'm for
7,
7, Mr. Marpan. Mr. Marpan
yes, where is he?
is appearing.
Have you sought his consent?
I have not informed him, Lordship. I'll inform him.
Let him have to be called up.
Yes, Lordship.
Item number 1.
May I please, Your Lordship? Lordship, this matter can it come up after a week, Your Lordship? The conducting counsel, Mr. Kharmuplang, is indisposed, Your Lordship, due to some medical emergency.
I've gone through this position. Are you empowered to make submission in this case?
Your Lordship, he's the
Yes, he is
Standing
a
counsel,
standing
Your
counsel,
Lordship.
but are you equally empowered?
yes, Your Lordship, but it's the matter. He's well versed in this matter, Your Lordship. I'm not.
Nothing is there. We'll admit your writ. You take steps. You are appearing.
I'm appearing for respondent.
Have you received notice?
I have received because there's another matter pertaining to same parties.
person,
Lordship.
same.
It's pending before this court, so they have served me a copy. So I've received this copy, Lordship. I'll be appearing.
You file your.
I'll file my power and my
Your Lordship,
affidavit. Lordship.
Let it come in a week, Your Lordship, then they can file there.
Any interim prayer?
Yes, Your Lordship. Your Lordship, what's the today? 182, Your Lordship, directing us the petitioner's office to pay the respondent, Your Lordship, the respondent authorities, page 182, Your Lordship. We direct the respondent authorities to grant a pay of rupees 4,600 in PB2 in bracket rupees 9,300 - 34,800 on the post of junior Hindi translator with effect from 24/06/2010 and GP rupees 4,800 in PB2 in bracket rupees 9,300 - 34,800 on the post of senior Hindi translator with effect from 01/06/2018 with all consequential benefits with a period of 4 months from or the date of receipt of the copy of this order. Well, Your Lordship, next year 10, Your Lordship, if you check next year
Yes.
10, Your
Page?
Lordship. 33, Your Lordship. 33.
Page 33.
33, Your Lordship.
Yes. I said
Your
that.
Lordship, serial number C, Your Lordship. Code number C.
Yes.
Your Lordship, the pay when the respondent was appointed in the year 2010 as a junior Hindi translator in the Office of Accountant General Audit, it's the same, Your Lordship. It's consequentially the same. Back.
This is the pay under the 5th pay commission.
6 pay commission, Your
Six.
Lordship. Your Lordship, let it come after a week, Your Lordship. Let Mr. Kamaplang.
There's no urgency per se because
It's
the
matter of urgency, Your Lordship. There's
the impugn order is 25th February 2025, and this matter pertains to service benefits. I don't think so. There's requirement of any stay.
That 4 months period is there.
yes,
Lordship.
4 months period
months
is there, Your
period is there.
Lordship.
Lordship. Otherwise, I'm be filing my
Only
affidavit.
if you
Prefer contempt. Lordship.
Yes, Your Lordship.
if you commit before the court that you will not take steps in contempt.
Lordship will not do that. Lordship. We're willing to contest the petition. Lordship.
Heard, Mr. Counsel for the petitioner was submitted that the petitioner being aggrieved by the. What's the date of the order?
25th February 2025.
Where is the impugn order?
25th February 2025.
Where is the impugn order?
Yes, Your Lordship.
Impugn order
Page 172.
172. And the impugn order dated 25/2/2025 passed in original application 4/00435/2019 by the Leonard Central Administrative Tribunal Guwahati bench. Directing the petitioner's authority to comply with its order so dated. The petitioner authority has approached this court with this instant writ petition. Notice on the respondent is not required since Mr. M.L. Nopier, Leonard Counsel, has entered. You file your power, Mr.
I'll file a lordship because
Has submitted that he is accepting notice on behalf of this said respondent, and power will be filed in due course. On consideration of the submission made by the Leonard Counsel, we are persuaded to admit this petition. Accordingly, the respondent is directed to file the counter affidavit within the next date fix. It is also the submission of Mr. Nongpure at the bar that in the meantime, no action in contempt will be taken up by the respondent as regards the said impugn order. This is matter up to 2 weeks.
Item number 2.
Yes, Mr. How long will you take?
Well, I have concluded my.
I have still started also.
Oh, you have just started.
I've started my last date. How long? Subject to the queries from the court, otherwise I should not take much time because the evidence has already been read.
Query comes from the court only when the counsel, fails to elucidate his case
Lordship.
Effectively. So,
Yeah,
if you can do it in such a way that we can vividly get your point, then query will not come.
Well, much obliged, Lordship.
Anyway, by the way,
Lordship, the other day
are there any other matter which may not take so much time? Matters that are in the list.
I don't know.
Oh yes. We'll just finish up with some of those matters.
Please.
I think some adjournment was sought for.
No.
Leonard,
number 7. Lordship.
he was not
Yes.
there. So
Lordship.
if he's here, we'll take up that matter. Dispose of. Then we'll take up the matter.
Yes, madam.
So that what we can do is we can leisurely take up the.
Comfortably can be.
Otherwise. Yes, Mr. Marpan, any?
Item number 7, Your Lordship, this matter has already been heard last year, but there's one thing that I would like to, with Your Lordship's permission, there's one thing regarding one document. I'm stressing on one ground, that is manipulation of one document, that is the birth certificate of the victim, that has been manipulated during the proceeding, in the trial. Now, through an RTI requisition, I have learned how this document was manipulated, how it was changed. There was nothing, so I would like to
Are
bring
you
that.
raising the issue of either juvenility or age of the victim, survivor?
Nothing as such. But it's because of this document which has been inserted at a time of evidence. There was no order. There was nothing in the record. How this document came into picture after the charges were framed. So that through an RTI requisition, I was able to obtain the information of how these changes were made. He
has sought for
yes.
accommodation.
So I will seek maybe in the next a week's time, if according to roster, if it's convenient.
2 weeks time then. Mr. H. Kharmi, Leonard additional PP, has sought for accommodation on behalf of Mr. R. Guru, Leonard G, who is conducting the matter on behalf of the state respondent on ground of personal difficulty of the said GA. Mr. S. Marpan, Leonard counsel for the petitioner for the appellant, has no objection to the preamble. Accordingly, list this matter after 2 weeks. Then anything else?
My lord, item number 5, this is a contempt matter. My lord, till that the contemptor is yet to comply with the order, my lord, which was passed by the tribunal.
This is that matter which my lords had actually heard at length. But quite some time back, we had also filed our written arguments. This is concerning that,
Heard
my
at
lords.
length, forgot in leisure. What do we see?
This was last year, as a matter of fact. This is that matter, my lords, where there's an arbitral tribunal, my lords, which had passed some interim orders.
I think vaguely remember. But Mr. Sankot, you're ready for hearing of this matter?
My lord, hearing was actually done, my lord.
You have to
we can
refresh the
file our
courts.
written arguments if
No,
necessary.
my lords would have to hear this matter afresh, my lords. This is one of those little tricky matters. We may have it after a week or 10
we
days.
vaguely remember the facts, but
My lords.
we still have to be refreshed.
Let it come after a week, my lord, then in that case.
Why not today?
My lord,
You can,
Here, my lord,
you can start.
yes.
I'm not saying right now. Because the other matter will be taken up first.
Well, may I pray your lordships have it on some other day? I am also a little bit under the weather. I just came down for this matter. My friend can start. I can respond if my friend wants to start. I can respond on some other day.
Mr. I think you start today.
My lord.
And let him reply maybe some other day.
My lord.
Otherwise,
we
if
can.
this goes on, we'll not be able to.
Lordships.
So we'll finish up the other matter and come back to you. Let it be called up,
Yes, ma'am.
Obliged.
I think after the other matter, I think yours will be the next one.
Lordships.
Second call, item number 2.
Okay.
Let's get the judgment.
Yes.
But Lordship, just to recollect the brief facts.
Yes.
Of course, my esteemed colleague had argued at length for more than 2 days, and he has discussed almost all the evidence. So, Lordship, except only if the court wants, then maybe I'll rely on those evidence. I'll just come to the main issues. Lordship, this is a case where FIR was filed against 8 persons. The 8 persons were named in the FIR. 2 expired, and the 8 are before the Honorable Court. The main thrust of the prosecution case, Lordship, is that there are 3 eyewitnesses, and one of the witnesses the first 2 witnesses, Lordship, have identified the place where the occurrence happened and also how the act was committed. So, in pursuance to this particular case of prosecution, Lordship, I had read out the deposition of PW1. So, just to refresh back again, Lordship, PW2 is very, very important for our present purpose. And he is the secretary.
Oh, yes,
Page 78.
But he is not. Was he an eyewitness?
Lordship, yes.
Okay.
Lordship, yes.
Page
78. Two.
Yes.
Lordship, the other day I made an important legal submission, Your Lordship, that the argument forwarded by my friend was embellishment, exaggeration, and improvisation. Your Lordship, these are ingredients that he has to assert in a cross to come within the meaning of contradiction, and then he has to also rely on 161. So no, that had never been done. Why I am saying this, Lordship? Because the moment I read this evidence, these are all unshaken evidence. In other words, proved. So once we read that evidence, if it's unshaken and proved, it becomes very easy, Lordship, for the court to go to the next next appreciation of evidence whether corroboration is there or not. So my first thrust, Lordship, will be PW2. His evidence in the in chief and cross are unshaken. So that means the quality of evidence in the PWD stands proved. Stands proof on 3 counts. Place of occurrences, and he is an eyewitness as to how was the murder committed. Number 3, Lordship, he identifies the murder weapon in the court on being shown and exhibited. So that's why the quality of PW2, the evidence of PW2 is very, very important in terms of place, in terms of seeing what happened, and also in terms of identifying the murder weapon.
Have he pinpoint the assailant?
Yes.
Who struck
Yes,
the fatal
Lordship,
blow?
I'll read it out. So, Lordship, just to get the legal background clearly, because then Lordship, otherwise I'll have to read everything, and then again the court will put a query to me. Yes. So, the moment we read these 3 parts, and these are unshaken evidence, in other words, these are proved evidence. So, it has not been contradicted. So, the moment we come to that conclusion on reading this, then the next task for the prosecution would be whether can we find any other witness to corroborate. It can on its own stand, but do we need any other evidence? So let us see the unshaken evidence of PW2. Allow me to just read page 78.
Yes.
I've received summon to depose before this court today. Lordship has got it.
Yes, yes.
In the month of October, I was holding the post of Secretary VC and one of the informant in this instant case. On 2nd October, but the year I cannot remember, now myself as a secretary and a chairman, Shri Nicholas Chadang, victim, and Srimati so-and-so have already distributed the NREGA schemes to all the job card holders of the village so-and-so. On the day of the incident, it was Sunday, the job card holders would include all the accused persons along with 3 others called for meeting at my compound without the knowledge of chairman or the secretary in connection with NREGA schemes of the job card holders to the effect that they have not received the said money as the chairman had misappropriated. So important thing is this, the motive for murder emerges first time here from the witness that the disbursement of money, they had not received the money. So that is very important, Lordship. I'll come back later on, but since we are reading out, so the ingredients of motive is very clear. What was the purpose of the meeting? E3 is the accused 3. Justin Swinson went to call the chairman to attend the said meeting at my compound. Place is his compound. However, the chairman said that it is Sunday, they could not hold any meeting. But E3 forced the chairman to attend the said meeting, even thought if it was a Sunday. Thereafter, the chairman, victim, had complied with the demands and attended the meeting at my compound. In the meeting, it was discussed about the misappropriation of fund of NREGA scheme suddenly, and all of the accused person. This is what I had stressed the other day, Your Lordship. All the accused person manhandled and assaulted the chairman.
Yes.
This evidence will cover section 34 of the Evidence Act, IPC, Your Lordship.
Yes.
Two important words that emerges here is this manhandling and assaulting the chairman. Wherein the fight they got one stick and bamboo and hit the victim on the head, and he then fell down on the ground. I helped the victim, but the accused person also tried to assault me, but I escaped and ran away to so-and-so village. Lordship, this is very important. He tried to help the victim, but the accused person also tried to assault. The eyewitness sees 8 person assaulting, manhandling, beating with a stick, falling down, and then when he tried to help, he was also assaulted. That is very, very important evidence, Your Lordship. It was not the case of any case of private defense or any case of provocation. They handled, and he tried to save, and he was also. This evidence is very crucial. But I escaped and ran away to so-and-so village and informed the uncle of victim, Sri so-and-so. Para 4, Your Lordship. After I have informed about the incident, I along with so-and-so and the villages of so-and-so proceeded to the place of occurrence where the accused person was still present. So, Your Lordship, the accused was still present and the victim was still lying on the ground. We then had a talk with the accused person which led to nowhere, and to some of the villagers advised us to inform the Sardar of so-and-so. And on getting the information, he proceeded along with us to the place of occurrence. Then he advised us to take the victim to so-and-so, and all the accused person along with us took the victim to the said hospital. Para 5 is what happened in the doctor of Rangdio CHO informed us that they could not medically treat the victim, so he advised us to ship him to hospital Shillong. We then took the victim to civil hospital Shillong, where he succumbed to his injuries on 4/10/2011. The doctor of the civil hospital conducted postmortem over the dead body, and after completion of the postmortem, we took the dead body to the village for the last rites and rituals. We then went to file the complaint, Exhibit 2 in so-and-so police station, and Exhibit 2 is my signature. Para 7 is very important, Lordship. The police visited the PO and they see some articles in front of me. These articles were produced in court today from the court's Malkhana, and with the permission of the court, it was shown to me. First was the articles were shown to him in front of the accused person in presence of both prosecution and defense counsel for verification and identification. Material Exhibit 1 is one wooden log, Material Exhibit 2 is one bamboo log, and Material Exhibit is one black shirt with strip belonging to the victim. The material exhibited was seized by the police from my compound on 6/10/2011. Lordship, three things are very important for the evidence of PW2. Compound is the PO. He is an eyewitness who saw what the 8 people did. And what was the weapon used in assaulting. Now, in para 7, he clearly, on being produced from the Malkhana, he identifies in presence of both the counsel, and he clearly says this is the weapon and which was recovered from his compound on 6/10/2011. Yes. So now, Lordship, this particular evidence of the prosecution, Your Lordship, has, now let us see the cross, Your Lordship, which is at page 81.
Yes.
I was present in the place of occurrence at the time of incident. After the incident, I went to the informed Shri so-and-so about the incident. When I returned back to the place of occurrence after informing him, the accused person was still present and standing near the victim. It is a fact that in other cases, after accused persons commit the offence, they fled away, but in the instant case, the accused person did not flee from the scene because they have stated that they have committed the mistake in commission of the offence. The incident took place because the accused person alleged the victim to have misappropriated NREG scheme. At first, the accused person assaulted the victim with his bare hands, but in the event A. Justin so-and-so hit the victim with a stick from his head. I know the contents of Exhibit 3. Lordship, basically, we see, if you read in between the line cross, there is no denial of place of occurrence, there is no denial of the assaulting, there is no denial of motive, money, and also made no denial they were not present. In other words, the eyewitness statement, Your Lordship, of PW2 has remained unshaken on 3 counts: place of occurrence, on having seen the conduct of all the accused and how they committed the offence, and also the same material exhibit on being produced in the court being proof. Yes. There is nothing in the cross to show that it has remained shaken or retraction or contradicted under 161. So my Lordship, this eyewitnesses, now the issue is now what happens, whether do we find the corroboration of this particular witness with any other witnesses. PW1 has already corroborated, Lordship, I read the other day. Now let us come to PW6, Lordship. He's another eyewitness. Page 88. Yes. I'm just reading the paragraph. I've received someone to depose before the court today. This case is in connection with the job card, NERGs, and misappropriation of funds by Secretary Shri Vishnu Syndrome. So motive of misappropriation, Your Lordship, PW1, PW2 and 6, we find corroboration. So far motive is concerned. And Saudar Nikli, it is on Sunday, the date I remember as it is on the 2nd, but the month I cannot remember, and it was in the year 2011. It was about 6 p.m. as I was having my dinner. One person, Shri Justin Chirang, came to inform that there is a meeting in the house of Secretary of the village, Shri so-and-so. After having my dinner, I proceeded to the house of Secretary. Secretary is PW2. Yeah. I attended the said meeting. When I reached the place, I heard some of the people were having heated arguments, and Janice Shangriang alleged that the headman Nicholas Shangriang had misappropriated the money. Then the headman slapped Janice Shangriang, and even Janice also retaliated by slapping him back. It is during the time that the crowd had tried to pacify both of them, and Justin Cherang was following from behind, and then he hit the headman Nicholas Cherang on his head with a bamboo stick, and the headman then collapsed on the floor, and then Protestius Bulla attacked the headman with a wooden stick. Misappropriation, Your Lordship, is the motive. This is another eyewitness. Not only PW saw it, but PW6 also corroborates. as eyewitness as to the actual act which led to the hitting of the stake by bamboos and this. He collapsed on the floor and then Portarius Bulla attacked the headman with a wooden stake. I can identify accused so-and-so by name and the face. He is present in the court dock today. Witness pointed to the accused while justice has already expired. Thereafter, the villagers from Masumi arrived and carried the victim to Rangdu Hospital and later to civil hospital. And I came to know he had expired on 4th, which is about 2 days from the date of incident. So there's no Lordship, the witnesses are very consistent in saying, witnessing the eyewitness and then CHC, and from there taking it to a civil hospital and dying within 2 days. They're all corroborating. Besides seeing besides being an eyewitness in the crime, I can identify, Lordship, this is important, I can identify Loris Zongman, Tarshish Shangriang, Revenus Dakhar, Jini Shangriang, Jeremiah Myanggoing by the name and face, and they are present in the court today. Witness pointed to Loris so and so and so and so. The police have recorded my statement. Now, Lordship, let us read the cross. This is continuing on the same page. It is not a fact that villagers called me. It is not a fact that the villagers informed me about the meeting. The meeting was held at the house of secretary so and so. I reached the meeting at 6 o'clock. It is not a fact that I reached after the incident happened. At the time of incident, there are lots of people present in the spot. I was about 8 to 10 feet from the spot where the deceased was assaulted, and there is no electricity in the PU, and the place was lighted by some firewood. It is not a fact that I have no knowledge whether the victim so and so was dead or not. It is not a fact that I did not witness the person who hit the victim. It is not a fact that I did not witness the person who hit the victim. It is a fact that I mentioned the name of all accused persons as their job card holders. It is a fact that I came to depose before this court to help the victim, who is my brother-in-law, concluded. One thing emerges, Lordship, he is the brother-in-law. But then, if you see, there is nothing except for being brother-in-law. Lordship, there are certain law. I don't want to go into that part of it. But
the law on interested witness is
absolutely, Lordship. Except if you can point out something. What I am concerned is from the whole paragraph, Lordship, there is a corroboration. That there was a meeting regarding the place. He has denied that he is not denied. He clearly says that it is not a fact that he is not an eyewitness to the actual crime. So, Lordship, 1, 2, 3 eyewitnesses have corroborated, Lordship, in terms of place of occurrence. 2 have directly corroborated who assaulted and what bamboo stake and log. There's a slight variation in the word stake or a log. So for bamboo is concerned, stake is concerned, they have all eyewitnesses have corroborated. Nothing has emerged from the defense as to remotely even whether this was not stated in 161. This is an embellishment or exaggeration which the court ought to overlook, much less to state in Lordship. The fact stated here directly contradicts. Now, she will recollect the first day when I made a submission, I started by reading out 142 only for the purpose. No contradiction is there in the cross-examination. So it becomes easy for the case, for this Honorable Court, Your Lordship, to just arrive at a conclusion that these are proved facts. Basically, I'm precluding this court for even entertaining the argument of benefit of doubt. Your Lordship asked me why I'm forwarding this argument. The moment ingredients of contradiction is not there. If there is a contradiction, Lordship, then the court says, okay, let us address the issue of benefit of doubt. But what happens if there is no contradiction? There are 3 eyewitnesses which has remained not shaken. And I read out the 3 cross-examination, no contradiction. In other words, if you go back to the definition of evidence, how is a fact proved? This is a classical case where the eyewitness have proved, and they will come within the meaning of sterling witnesses, because they will inspire confidence to the court that there is no reason why will they say these facts. So if these 3 eyewitnesses have clearly demonstrated on oath as to what has happened, Your Lordship, then I don't think so. The prosecution's case suffers from any any kind of reasonable doubt, much less to say there is no doubt at all. Now, Lordship, insofar the material exhibit is concerned, I'll just take your Lordship to PW8 IO. '92. Relevant page will be, Lordship, only for the purpose of that, page 93.
Yes.
On being shown to me the material exhibits seized as per exhibit P31, confirm that material exhibit 1 is a wooden log stick. So, your Lordship, first time you find log and stick. Of course, it would mean the same thing, but for our clarity, your Lordship, it could be a linguistic issue, but log and stick. Material exhibit 2 is one bamboo, and material exhibit 3 is torn navy blue white strip shirts which has come off from the body of deceased as stated by so and so. On being shown, in Lordship, the IO on oath has also admitted and corroborated PW2's statement that material exhibit 1 and 2 are the same. Thereafter, I examined and recorded the statement of so and so and so and so and so. Then after that, I went to the house of deceased and arrival. I checked the body of the deceased, which has not been kept in the coffin and had also not covered, and found one injury mark on upper portion of head, and it looks like it was caused by a blunt object. Now, why I'm reading this part, Your Lordship? The material exhibit, there is a corroboration of material exhibits given by the IO and PW2. Now, he says very clearly, Lordship, upper portion of the head, and it looks like it is caused by a heavy blunt object. Yes. Now, Lordship, to answer blunt object, whether now, so we have identified the material exhibit 1 and 2, the murder weapon, but whether that exactly has been a cause of death, we find the IO saying it was a case of blunt object. Now, on its own, whether it can now the prosecution has to prove whether the theory of blunt object or a sharp object. If it's a sharp object, we have a problem, Lordship. But the blunt object, does it find corroborations with the post-mortem report? And I will come to doctor's report, Your Lordship. It does find corroboration. Page 177, Lordship. Come here, PW, one. PW. Lordship will just come to page 177.
177.
Lordship. In my opinion, Lordship will just go through that part.
Yes.
Lordship, first we'll come to page 177.
This is 177.
First is 171. 171, Lordship. This is very important. Before I come to post-mortem report, Lordship, just see what happened. What was the finding in the inquest report? So, police statement of blunt object.
Yes.
Because post-mortem was done later, Your Lordship. We can't overlook inquest.
Yes.
Page 171, clause 4, Your Lordship. Lordship has got it.
Yes.
171. Injury mark. During the inquest, the dead body was perfectly checked and turned up and down, but found only one head injury and no other parts of the body. The police IO statement of blunt object and head injury. Head injury also finds corroborations in the inquest. No other injury. Now, after that, Your Lordship, what was the object? Obviously, inquest can't say that. It's only the post-mortem. So, let us see 177. Type copies at Lordship, the type copy is at page 182. Police says head injury, Your Lordship. He can't say. Police has got no business to say what was the cause of it.
Yes.
The head injury has to pass the test of inquest report. It has passed the test of report. What was the cause? The only expert that can say that is the postmortem doctor. And Your Lordship, page 182.
182, 182.
182. Type copy is 182, Your Lordship.
Yes.
Lordship, the right side table, the second table, Your Lordship, if dead body part.
Yes.
Dead body belongs to male, adult, person in rigor mortis. He sustained head injuries on the head caused by blunt object. That is very, very crucial.
Yes.
Head injury caused by a blunt object. Conclusive proof, exhibit log, corroborated by plea 1, 2, 3. On investigation, corroborated by police, PW8. In inquest, the head injury stands consistent, and in post-mortem report, head injury and blunt object. Now, Lordship, the same page, Lordship, he gives in the below his opinion. In my opinion, the cause of death is due to shock and internal hemorrhage caused by a head injury. Not only has the doctor identified the wound,
yes,
he is also given his expert opinion.
Yes.
Now, Lordship, this particular opinion and observation of the doctor has not been shaken or disproved in the entire cross-examination.
Yes.
There is no question of any doubt. Now, the moment we see inquest report, police statement, doctor's opinion, seizure, exhibits, there is totally consistency regarding the object used for murdering the Lordship. There are a lot of other issues involved here, Lordship, but I don't think so. Only if the query comes from the court, but I'll just rely on the false statement given by the accused in 313.
Yes.
Now, why it is very important, Your Lordship? Because if the accused had admitted regarding what had happened, and more important in this particular case, it was very important for the accused to admit, because there are eyewitnesses who saw it. Number one. And the eyewitness statements has not remained shaken. Now, if a question is put to them in 313, and if they make a false statement, what is the consequences?
Where is 313?
I'll come, Your Lordship. 313 is at page 100. Question number 1 is a detailed deposition of PW1, which is at page 100. Lordship, I will not take to the deposition. Lordship can at leisure go through it. Basically, what is the PW1 stated? Not, Lordship will kindly see the answer.
Where is the question number 1?
Question number 1 is at page 100, Your Lordship.
Yes. What is the reference to any discriminating evidence against the...
No, the question number 1 is PW1 Shri so and so that he was one of the complainant in the instant case. It starts with that, Your Lordship. Narration as to the evidence that was recorded by PW1. Now, there is a very detailed discussion on the evidence. Lordship will kindly see the reply. It is not a fact that I have assaulted the deceased Nicholas Changreo. He denies clearly, Lordship. He denies the assault part. Basically, in the teeth of an eyewitness is, had he remained silent, maybe things would have been different.
Yes.
But if he chooses to give a wrong statement, Your Lordship, law is settled, Your Lordship, court can draw adverse inference, and that will add to the evidentiary value. His false statement, court can draw an adverse inference. There's a settled law on that, Lordship. I'll just rely on the judgment later on. Court can rely that the adverse inference can be drawn that he has made a false statement. And that adverse inference can only strengthen the case of prosecution. If we choose to remain silent because 3133, he has the liberty to make a false statement. And the rigor of 341, Your Lordship, 341 CRPC clearly says if you make a false statement, court can sue more to initiate a proceeding of perjury. But that is not applicable, 341 is not applicable to accuse in the 313, because 3133 gives power to make a false statement.
But yes.
But Lordship, only on the law point, I'm just trying to say what, because this is very important, because now we have a situation where the eyewitness account,
even if he states anything that is not correct, that will not go against him.
Then the court will never invoke 341. Lordship wants, I can just take to 341 of the CRPC. What is the consequence of giving a false statement? It will not be applicable. But what the Supreme Court has laid down, Your Lordship, if he gives a false statement, court can draw an adverse inference. Adverse inference. What is the purpose of the adverse inference? It will only strengthen the case of prosecution. Add another point. And I'll come to that, Your Lordship, only on that legal position. Lordship will come to page 101, question number 4.
101. All the accused.
Lordship, all the accused. But I'm just taking one of the accused, Lordship. I'm just taking because they have made the same statement.
Same,
almost same. And it's not a separate appeal, Your Lordship. Had it been a separate appeal, we would have taken every case individually, Your Lordship.
Yes.
Now, why question number 4 is very important, Lordship. Who is PWT, true, Lordship?
Yes.
The prime eyewitness.
Yes.
Lordship, he is the prime eyewitness in whose place was the PO, who saw assault and manhandling being done, and who also exhibited the material exhibits. Eyewitness not shaken, his evidence stood proved. Now, if such a sterling witness's statement is put by the judge under 313, it's a very dangerous situation for the accused. The burden of proof, reverse burden of proof, is very, very crucial for the accused. He chose to remain silent, then things are different. Now, Lordship, kindly see his reply in page 102. Lordship has got it. A bold letter.
Page
102, Lordship.
102.
PW2 is a sterling witness, unshakable. Have proved the case with certainty. Now, what is the reply, Lordship? He says, it is a fact that I was present at the meeting. He is not denying, Lordship.
Yes.
But I did not assault the victim. It's an open as daylight that he is making a false statement.
Yes.
We can imagine, Your Lordship, but I did not make a false victim before. We can imagine if this question was put in cross and a doubt was created, then I would have not forwarded this argument, Your Lordship. Because then it remains a grey area. But no cross, proved evidence, and 313 happens when the evidence is close, just to clarify certain facts. But if you choose to lie on the teeth of an eyewitness, there is a consequences. It adds brownie point to the prosecution case. He says, I did not assault. It is also a fact that I am a job court holder and the meeting was not called by me and co-accused but by so-and-so. We are not concerned with, Lordship, at least he admits the part where he was present, but his categorical denial that he had not assaulted. The court would look into the cross-examination to find whether such questions was put, contradicted. Nothing. I read out Your Lordship PW2. Nothing. So this is an open and shut case again of false statement. And if it's a false statement, it strengthens the prosecution case that it has proven the case one step further. Question number 5, Your Lordship. It's not so relevant because it doesn't connect. It just concerns with going to the hospital. Question number 8, Your Lordship, he admits. So it's regarding misappropriation of so and so and was commotion page Your Lordship. We will just stick to page 103. Question number 8 is very important, Your Lordship. So far the motive is concerned, he admits. 1, 2, 3, 6 clearly draws out the motive. Now whether the motive part on being put to the accused, whether he admits or he denies. This is a case where he admits. The moment he admits, Your Lordship, motive is further strengthened and corroborated even by the statement of the accused. He says, the question, Lordship, is PW3 so-and-so states that the case relates to misappropriation of fund of so-and-so scheme and there was commotion of the village. Because of the said misappropriation alleged by some of the villages, which also include you and all the accused person, when he reached the PO, the victim had already been assaulted and he had already fell on the ground, and thereafter he along with you and all the accused persons took the victim to so-and-so. What do you have to say? Very, very important question, Your Lordship.
Yes.
He say it is true. Motive, assault, falling in the ground, or the prosecution theory also finds credence and corroboration by question number 8.
Yes.
So, Your Lordship, if in totality, you will see the 3 eyewitnesses, the material exhibits, and the statement of 313 statement.
Yes.
Prosecution has proved the case beyond reasonable doubt. Now, this is a case of 302, red with 34. None of the eyewitness has been shaken. The material exhibits have been proved. The post-mortem report, the inquest report, there is consistency. Prosecution has to prove the case beyond reasonable doubt, Your Lordship. In this case, when we understand reasonable doubt, Your Lordship, it doesn't mean with complete certainty. It means maximum probability. And in this case, Your Lordship, the prosecution has proven the case beyond all reasonable doubt. There is no infirmity in the impugned judgment. Lordship, 2 important arguments that my friend had raised. I'll come to the first, I'll just try to answer the first query. So the query was that, I'll just get the factual background, Lordship, that one of the Seizure witness had said something that it was not seized in his presence. There was a legal argument raised that one of the Seizure witness, and what is the consequences of that? Our admitted case is this, Your Lordship, PW2 and the IO have proved the seizure, material exhibit 1, 2 and 3. Now, in the absence of any Seizure witness retracting or feigning ignorance or not supporting the prosecution, but otherwise if somebody else, means other witness supports, what is the law on that? Will the seizure stands under doubt?
So this is
Okay, where is that?
1979.
1978, Your Lordship. 1978. Lordship, we are relying on para 9.
Yes.
Para 9, Your Lordship. The only material on which the prosecution can connect the appellant with the crime is the recovery of fired cartridge, Exhibit 9, and the seizure of pistol and the deposition of ballistic expert. It is found that the witness who have examined for attesting the seizure have not supported the prosecution version. In our case, one witness did not support. That is a thrust, Your Lordship. On behalf of the defense, it is submitted that seizure witnesses were men of status in the village and were not supporting the recovery would be fatal to the prosecution. We would rather not place any reliance on the witness who attested the seizure memo. Court was of the opinion we will not place reliance. Why? They explain now, Lordship.
Yes.
It is the evidence of the investigating officer. Lordship, kindly pause for a minute. Our cases, it is the case of PW8 investigating officer and PW2.
Yes.
Kindly read in place of investigating officer. So far our case is concerned, PW8 and PW2 who recovered the material object is convincing. The evidence as to recovery need not be rejected on the ground that the seizure witness do not support the prosecution version. Directly and substantially covering our case. In this case, one of the seizure witness, that was one of the arguments forwarded by my learned friend, and whatever the seizure witness does not support. In place of only things is in place of IU, Lordship, we have got PW8 and PW2 who supported, who identified and exhibited. So the prosecution case cannot fail, or the seizure cannot be considered as dehour of law just because one of the witness retracted or resiled or whatever happened, Lordship.
Yes.
If it is to prove, give a copy to him. Same issue, Lordship. This is a 2011 judgment. We thought maybe 78 could be too old, but luckily for a bit of research work, we got 2011, para 68. Para 68 and 69, Lordship. Can give you 313 judgment, 313. It's okay. Lordship, for the purpose of this, Lordship can just go para 68, sub para 2. The relevant paragraph, this is just to build up the case, Lordship. The relevant paragraph would be para 71. But 68 says, Lordship,
yes,
slightly different from our case because here both the witnesses,
yes,
here both the witnesses have denied having knowledge of the actual recovery of the weapon at the instance of appellants. The denials do not appear convincing. However, since the IU of the case so-and-so has proved the seizure memo, we find no reason to hold that there is no seizure and that was effectively merely because two seizure witnesses had turned hostile. Same argument, in Lordship, PW2 and 8 has proved it.
yes.
And Your Lordship, further, Your Lordship, para 69.
Yes.
Even assuming that the seizure of the weapons were effected without meticulously following the procedure, and thus doubtful, in view of the medical evidence, which clearly shows that the deceased died because of injury caused by sharp weapon, which has been seen by direct eyewitness, so and so, in our opinion, it would not prejudice the prosecution case. So even if you discard the entire Seizure witness and the IO, but the medical evidence, as I read, Your Lordship, medical evidence, PW2, inquest report, and doctor's post-mortem report clearly points to it was done by a blunt object and seized. And then relevant part, Lordship, is para 71.
Para 71.
71.
Yes.
In this context, one may also refer to a decision of this court and so, in which it was observed that testimony of the police personnel involved in recovery of articles need not be disbelieved, and testimony of police personnel is to be treated similarly as the testimony of any other witness. It was held. This was the finding, Your Lordship, and the observation is in the last line. Thus, we do not find any reason to doubt the testimony of police IO. So even if you take independently, Your Lordship,
yes,
only PW8, court cannot be doubted. Doubt can come, Your Lordship, when it is shaken in the cross. Again, my primary argument, Your Lordship, no contradiction. We understand the situation, then we would have had to go back to PW2. Now, IO's Seizure finds corroboration with PW2.
Yes.
No. I wanted to para 23. Yeah. Lordship, I will be. This is another argument on law, on 313, and where you make a false statement.
On seizure?
Seizure, sorry, apology, Your Lordship. Seizure basically, the procedural not requirement is immaterial when it is corroborated by PW 2 and 8, even if you take independently.
This is on 313?
Yes, Lordship. No, Lordship, not, sorry, not this judgment, not this. I apologize, Lordship, not this judgment. Not. You take out, wait, sorry. Take out. Para 76 of take out this again. Just for a minute, Lordship, apology. (2012) 174. Next judgment I'm relying on is 2012 6 SSC page 174. What? No, I don't. You given the list? Not given to the court. Not given to the court. No. Lordship, I'm sorry we don't have an extra copy, but I'll just hurriedly just get it. Lordship will just have a look at para. Please, sorry. Apology, Lordship. I'll just give the copy. We missed out the printout.
You should have you given? You have not given the.
No, we have given the list, Lordship, but this judgment was inadvertently missed out. Lordship, kindly have it. We'll just give it right now within 10 minutes. Apology, Lordship. Lordship, can you just read para 76, please?
What is the citation?
2012 7 SSC 174.
One?
On your Lordship, false statement under 313.
Page?
relevant paragraph is para 76.
2012 7 SCC,
Page 174.
174. Para 76.
Para 76. Lordship, can you just go through it, please? Apology for not giving the soft copy.
Well, this proposition is well settled.
Lordship, my thrust here is, Lordship, if you make a false statement, the court will have to draw an inference reference in 313. Adverse inference. Adverse. No, Lordship, the rigor of 314 will not be applicable, no false statement. But then supposing in 313 you make a false statement, what is the consequences? On the face of eyewitness statement. If you remain to choose, Lordship, I would have not relied. I said they have ignored it. So this is an additional ground which will strengthen the court. Sorry. Lordship, the last.
Mr. Khan will continue on the next date.
Lordship. I won't take much time, Lordship. Next date maybe another 10 minutes because another 2 more judgments and I should be over.
We'll wrap up. You can continue.
10. So, Lordship, para 76, Lordship, just want to read the last line. If the accused gives incorrect or false answer, during the course of his statement under 313, the court can draw an adverse inference against him. 2. In the present case, we are of the considered opinion that the accused has not only failed to explain his conduct in a manner in which every person of normal prudence would be expected to explain, but had even given incorrect and false answer.
You were referring to his to the reply on
313, Lordship. 313 question 1, 2, 4, where PW2 statement was deposition at page 91, 100, Your Lordship. I will just read on that. So, and
when the incriminating aspect of PW2's examination,
Lordship,
chief or cross, was put to this accused,
Lordship.
He has
made a false statement. Lordship. That is why I just wanted to. I want to just go slow, Lordship.
On what aspect?
On the aspect that PW2 said I was present in the place and I saw you assaulting. PW1 and 2 has stated in chief. Now what do you have to say? Had he remained silent, Your Lordship, there is no question of adverse reference. But if he chose to say no, it is not correct, and he categorically stated it is not correct, then what is the consequences?
Where did he say that they were not there?
He stated, Lordship, if I just come back to
answer to question number 4.
Lordship, question number 4.
He said, I did not assault the victim.
Lordship, he did not assault, absolutely. Why this is a false statement? Because 1, 2.
He was pointedly identified by PW 1 and 2.
2, yes. And he was identified in the top also.
Yes, Rabunas Dakhar.
Lordship, yes. They were all collectively identified.
Because PW 1, PW 2, you see, they have pointed, they said that, in fact, PW 2 did say that
manhandle and assault.
The person who had dealt the fatal blow,
correct,
was, I forgot the name.
One of them, yes.
One
yes,
of them.
Lordship, that's correct.
Not necessarily this.
Correct.
So he may say that I was not there.
Lordship will kindly see page 100, question number 1.
So only adverse inference will go. You can answer. To clarify. it will go against some.
What happens to 313 sub clause 3? Section 313 sub clause 3. How do we read together with this judgment?
Lordship will kindly, sorry, I didn't give the copy. So just allow me to read this para 76 for a minute.
You read it out.
No, I have the relevant part I have not read out, Lordship. If the accused gives incorrect or false statement, answer. Lordship, my first submission would be he will have an immunity under 341. 341 is when the witness gives a false statement.
Have you seen 313 sub clause 3?
Yes, he can give false and true statement. No problem. But Supreme Court has interpreted what is the. I am only into the consequences, Your Lordship, because 313 does not talk about what is the consequences. It talks about he is the liberty to give a false or true statement. Now, Lordship, this particular paragraph.
It says if he gives a false statement or wrong statement, that will not render him to his punishment.
Under 341. Lordship, can you see CRPC 341?
Something is provided in 313 sub clause 3.
Lordship, yes.
That is the language.
Lordship, we are not talking about punishment. Lordship is correct. I am not disagreeing with it. I am into the corroboration part of adverse inference. This is exactly what para 76 says, Lordship. Lordship, kindly just allow me to hear me out. I may be wrong, but just hear me out. If the accused gives incorrect or false answers during the course of his statement under 313, and the court can draw adverse inference against him. Not punishment, adverse inference against him. That is, first is against him, number one. In the present case, we are of the considered opinion that the accused has not only failed to explain his conduct in a manner in which every person of normal prudence would expect to explain, but he is even given incorrect and false statement. He is given incorrect. Now, the last part is very important, Lordship. What is the consequences?
Just a second.
Sorry.
Now, certain situations put before the accused. When one witness says that I have seen the accused committing murder.
Lordship.
Now, when that situation is placed before the accused in 313, he says, no, I have not done it. Is it false statement?
Lordship, it will be a false, according to me, with respect.
So according to you, that then the duty is cast upon the accused to admit a guilt against him.
Or he can choose to remain, no, Lordship, not duty is cast. He can choose to remain silent.
His silence again will lead to presumption of adverse inference.
But Lordship, before going to 313, so far accused is concerned, court will have to look what happened in cross.
No, we are asking, you see, here basically not directly answering the.
No, Lordship, the answer is very simple. Answer is very.
This court is asking you when, say, a pertinent question is asked to the accused about commission of offence by him, and if he denies it in 313, will it amount to a false statement or incorrect statement?
No, denial will not be a false statement.
What will be a false statement or incorrect
false statement will be, Lordship, he is categorically stated, I did not assault. Lordship will see page 100.
But then he has assaulted is on the basis of some evidence, isn't it?
Lordship, yes.
If he says that I have committed the assault.
No, Lordship, pause. No, Lordship, pause for a minute. Very, very important legal question, Lordship, is that assault part is a proved evidence of the prosecution and on oath.
That is according to you.
No, according to law, Lordship.
According to you, what is proved and what is not proved?
Lordship, according to law.
Just a minute. What is proved, what is not proved, we can say only after judgment is rendered. Not before that.
Lordship is correct.
Then 313 comes not after judgment, before judgment. How do we say it?
Lordship is correct. There has to be a finding. Lordship is correct. See, Lordship, I am only into Lordship will kindly.
Certain things.
Yes.
Probably you know, you are an expert. Probably.
No, Lordship is correct. I agree with you.
See, certain question remains.
Yes, I agree with you.
Now the earlier judgment on Seizure, which you have placed before us, the apex court judgment, where the seizure, it was pointed out paragraph 68 or 69 and you
68, 69 and 71.
The gist of which is that the seizure witness denied of knowledge of the seizure. And then the Supreme Court said, the observation was there, that denial seemed to be not convincing. Now in a criminal case, which way we say that? Where we say that? Do you say it by taking into consideration delegation of the prosecution? We can say it only when we only have a preconceived mind. Otherwise, to say it in a criminal case. Now, in what situation that can be said? That will be up to you to project before the court.
Lordship is absolutely correct. It will
not convincing.
Lordship is.
And for a witness especially, it is not for the accused. Then in what situation?
Lordship, if you see the prosecution case, Your Lordship, I was just trying to building up the additional evidence that supports the prosecution because there were 3 eyewitnesses. Otherwise, I would have not forwarded a 313 argument, Lordship. I know it's a grey area. Let me admit. But Your Lordship, the last line of this Honorable Supreme Court judgment that says if it's a incorrect or false power, Lordship is correct. Who will decide falsity? I leave it. Your Lordship is correct.
No, the court will decide. But then
Absolutely. Now before.
That's how do we?
Lordship, there's a grey area. Let me admit, it's a grey area.
These are the things. The few question comes because it is not that we get enlightened by the bar. What you place, you want clarity on that. Otherwise, you see like that reading 313, subclause 3, and the very judgment of the apex court, we find that there is some certain conflict insofar as the proposition.
Yes, Lordship is correct. Lordship. That's why, Lordship. That's why, if you allow me to just read, I think so. Lordship, the query of the Lordship is answered in the last line. If it's an incorrect or false statement, in the present case, the court not only draws an adverse inference, but such conduct of the accused would also tilt in case in favor of prosecution. Lordship, I think this is answered it. Court will draw an adverse inference not on the falsity. Lordship is absolutely correct. Falsity will come in a judgment. But then we have to understand what would be the meaning of adverse inference. And this adverse inference will be one more mark in favor of prosecution. They have proved the case.
You are very modest. That is a very modest kind of.
No, sure, I agree. I'm being enlightened.
Because of the situation.
Yes.
You are not saying that adverse inference will lead to direct punishment. You said that is one mark.
One more mark. That is what I was trying to grow very slow on the last paragraph. In the present case, the court not only draws an adverse inference.
Is that argument is made on the given situation or?
Only in the given situation. Lordship, I will never forward. I will not forward in this argument. Lordship, is a very grey area, I admit. But I am fortified by 3 eyewitnesses and medical. That is the situation. Had it not been eyewitnesses, Lordship, had my
these propositions are concerned. Say supposing if we have to say something in our judgment, now this will again become a precedence. That is what we are concerned. So if we hold certain thing, we must be sure that it is correct.
Yeah, Lordship, this is a grey area. I'm just honestly, Lordship, hardly Mr. Khan's opinion will matter because the Supreme Court has given a finding. Court can take any view because this will not affect my prosecution case. I'm only scoring one additional more mark, only for the purpose of one more admissible evidence.
See, judgment which you have read out on 313, this probably takes into consideration the situation. In view of the provision of 106 Evidence Act, where accused needed to explain certain situation. Now, this situation normally arises when you say in the place of occurrence, the presence of accused is not disputed.
Correct.
But then he fails to explain his position in 313.
Absolutely correct.
There the question of inference comes.
Absolutely correct.
Otherwise not.
Otherwise not. The only thing is
that is what discourse understand is until and unless you see like a.
No, Lordship is correct. I admit, Lordship, is a grey area. I'm just going by the letter and spirit of Supreme Court's observation. I'm not going to add into it because I know I'll be treading into an area which I won't be able to legally sustain my argument. Because what has fallen from your Lordship, incorrect or false, that's absolutely correct. At what stage a statement of an accused becomes false?
Incorrect and false probably we say by taking into consideration the admitted situation.
Absolutely. Now, Lordship, if I just follow through from what has fallen, my position is this: if you read the backdrop of my eyewitness statement not been shaken and contradicted, again I will not say proved. I'll say these are admissible evidence. Now, in the face of an admissible evidence, if he makes a statement in 313 which directly contradicts, the law is settled, Lordship, which will prevail? An eyewitness account will prevail or his statement? So let us not use the word false statement, incorrect. So Supreme Court has clearly stated in 2 situations, incorrect or false, court can draw adverse inference. I think I'm just trying to make it clear, Lordship. Lordship, I think I'll just conclude my hearing, my prosecution case only on the Seizure witness in the 313, because the rest, Your Lordship, I don't think there's any doubt created by my friend. So I'll just try to rest my case, Your Lordship, that the prosecution has proven the case under 30234. Beyond any reasonable doubt.
This aspect would not be your emphasis.
Lordship, no. But this was very unique case where I thought I may make an attempt. And if the court finds no still a grey area, Lordship, I'll withdraw my argument. It doesn't affect my case, but it's a very interesting provision of law. Normally, Lordship, in any other case, it's very difficult for prosecution to build up 313(3). Only when it's an admissible evidence on the face of 313, then maybe we can make an attempt.
Because there is no issue of perjury here.
It will not come. Lordship, kindly see 341 of the CRPC.
Exactly.
It will not come. 341 of the CRPC gives complete summary power to the court after the judgment or before that to draw up summary proceeding for perjury, for giving false statement. That is not the case. That is not the case. My only limited argument, Lordship, would be only on the purpose where the court can draw adverse inference. Means can we score one more point? 313 accused statement by making an incorrect statement basically builds up the case of prosecution, in my limited submission. In this case, if I just humbly submit, the admissible evidence of 3 eyewitnesses clearly comes within the meaning of incorrect, and court may venture to draw adverse inference.
You see, if we go that would entail a very lengthy discussion on this, as far as the import of 313 is concerned. You have to first understand what is the nature of the witness, or the accused. His capability of understanding the question, whether the question was put to him properly.
Very true.
And whether he is made to understand that he need not answer. He need not implicate himself.
Absolutely correct. And both the counsel's defense and prosecution has to assist the court in giving the right question. Absolutely.
Whether just to try and escape the news, he say anything.
Absolutely correct.
These things have to be taken, which is out of bounds. So we'll rest it at that and see.
No, because this was a very peculiar and unique case, Your Lordship, and I thought maybe if we can venture out, because normally we can't. I can never forward an argument like this in the absence of shakeable witness, contradiction, no corroboration with medical, inquest defective, and then the Seizure witness is saying something and the finding is different. Everything is consistent, Your Lordship, and there are 3 eyewitnesses which supports an admissible piece of evidence. An important legal issue is this: is this a case where court can presume to draw an adverse inference only for the purpose of scoring some point for the prosecution? If yes, Lordship may consider it. If not, court may consider overlook this argument. I rest my case, Lordship.
Yes,
I'll just give the judgment of para 76.
Yes, Mr. Nath. Anything else?
Well, only on 2 or 3 points. I'll not take much time. Please, Lordship. Well, my learned friend has submitted about the corroboration, my lord, of PW2 and PW6 and PW8, my lord. And now, my lord, I would like to point out on the point of corroboration, my lord. PW2, who said
yes. PW2
in page 78.
Corroboration of PW2, PW6
and 8.
PW6 and PW8.
That was mainly mentioned by my learned friend. And firstly, PW2, my lord, on that point of the recovery or the incident. Now, my lord, here PW6 said that point repeatedly. I have also argued before that all the accused persons manhandled the assaulter and chairman were fight. They got 1 stick and bamboo. Now, my lord, but stick and bamboo, my lord, in the seizure list, it has been seized bamboo log and the wooden log. So, my lord, this is not inconsistent, number one. Number two, my lord, in paragraph 7, as mentioned by my learned friend, that these materials were seized by the IO from the PO. Now, IO said, my lord, these material exhibits were produced by PW2 from his home, where he kept for 4 days, and then he produced it before the IO. But PW2 in paragraph 7, in page 79, in first line says, the police visited the PO and they seized some articles in front of me. So, from the PO, my lord. So, that is inconsistency, my lord. This is not corroboration. We cannot say it is corroborated. Secondly, my lord, in cross-examination of PW2, last paragraph, paragraph 2, the incident took place because the accused person alleged the victim to have misappropriated the scheme. At that first, accused person assaulted the victim with bare hands, but in the event, accused 3, Justin Shirang, who expired during trial, my lord, hit the victim with a stick from his head. I know the contents of this. Now, what PW6 said, my lord? PW6
is a doctor.
Oh no, it's not a doctor. It's another eyewitness, as mentioned by corroborating the statement, who said that it was hit by one Janice. My lord, I am coming. PW6, which my learned friend has categorically read the portion, is paragraph 2, where it says, when I reached the place, I heard some of the people were having heated argument, and Janice Sangyang alleged that headman Nicholas Sangyang has misappropriated the money. Then the headman slapped Janice Sangyang, and even Janice has reiterated this slapping. That portion was not been highlighted, my lord. It is during that time the crowd has tried to pacify both of them, and Justin Chirang was following from behind, and then Justin Chirang, hit the headman Nicholas Sangyang on the head with a bamboo stick and headman. Then collapsed on the floor, and Protasius Bula attacked the headman with wooden stick. Now there is it been said that one person has hit. Justin has hit the person with bamboo and stick. Here the same witness as taken as corroborated and eyewitness has stated that there are 2 persons has hit the victim. One later by Protasius Bula attacked with headman with wooden stick. But earlier it says that it was hit by Chirang. Now number 8, my lord. Number 8 said, this is the main person, my lord, who is secretary of PW2, and who was the person who is also one of the seizure witness, also one of the witness of the inquest report, and the direct eyewitness as per the submission of my learned friend. My learned friend has read his statement in page number 3 on the point of seizure, where it says log and stick, he has mentioned, my lord. But previous paragraph, my lord, where it has been specifically stated that, page 92, my lord, from paragraph 2. Accordingly, on 6/10/11, I started my investigation. First, I visited PO, which is located at the house of Vincent Sangyang, who is the PW2, my lord.
Yes.
At the village, at the PO. First, I examined the complainant, Vincent Sangyang, who is PW2, my lord. Available eyewitness, namely Jasrin Sangyang, Sri Stephen Langsni, and Matilda. And after that, the complainant Sri Vincent Sangyang produced and handed over 1 bamboo stick, 1 wooden stick, 1 shirt, which was reportedly belonged to the deceased late Nicholas Sangyang, which was accordingly seized by me in the presence of available witnesses. Sri Vincent had taken the seized items from the compound and he kept it in his house. The seizure list was accordingly prepared. Now, my lord, here it says bamboo sticks and wooden stick. He also says bamboo stick and wooden stick. But others are saying bamboo log and wooden log, my lord. There is a difference. Now, I have already submitted about the defect in seizure list. My learned friend has submitted that the seizure list has been proved. One of the seizure list witness has stated that I have not seen from where and how it has been seized. This is my submission. And another witness is PW2. Now, everywhere is PW2, my lord. And he is the interested person of misappropriation of the fund. That is my submission, my lord. My lord, as such, the corroboration which has been submitted, my lord, is not corroborated. There is a discrepancies in three eyewitnesses, my lord. In this only in regard. And 313th, my lord, already has been explained, my lord. And the judgment, my lord.
Lordship, I've given the copy of the judgment, Lordship. Sorry, apology for not giving earlier. 2012.
You file your written argument?
Written argument? Yes, madam.
Bullet point, Lordship. We'll try.
Bullet point or otherwise, it doesn't matter. As long as it is discernible.
Para 76, Lordship.
Mr. K. Khan, PP, who has concluded his argument on behalf of the prosecution. Mr. H.R. Nath, counsel for the appellant, has then made a short reply to the said argument, and accordingly, hearing is concluded. The counsel has submitted that written argument may be allowed to be filed. When?
2 weeks, Lordship, within 2 weeks. Up to you.
After 1 week, my lord, we will prepare.
1 week or 2 weeks?
1 week. Things are fresh.
That is, accordingly, this is matter up to 1 week for filing of written argument.
I will bless.
I should be grateful to this court, Lordship. At least some principles of law, at least we can expound whether it's admitted or not, because a lot of grey areas are there.
It emanates from the argument.
Lordship. There are some cases which
court doesn't form anything of its own.
Lordship, but sometimes it happens because we have to formulate, and just I'm saying I'm very grateful that the court allows us to argue in that plan. Much grateful.
Yes. Thank you.
Item number 5.
My lord, this is a contempt petition, my lord. If I can take your lordship directly to the order that has been violated, that is at page number 19.
Yes, sir.
Page number 19, my lord. My lord, this is an order dated 8/11/2023, my lord, passed by the tribunal. If I can just take your lordship to the order.
in terms of the last order, the proceeding is taken up today through video conferencing. Mr. Amit Kumar, Learned Advocate General of Meghalaya, appearing for both the respondent 1 and 2, has drawn our attention to the content of the applications filed by the respondent number 1 under section 17 of the Arbitration and Conciliation Act 1996, praying for an interim order for payment of monthly rent of the subject premises by the claimant from the date it remains unpaid. He has drawn our attention to the fact that the claimant has, in so many words, in this proceeding by filing their reply to the applications and also in terms of the documents filed herein has admitted that they are in possession of the subject premises, but the rental thereof has not been paid despite such occupations on the ground that the respondents have failed to carry out their responsibilities like non-completions of the work in the food court and non-providing an occupancy certificate to the claimant as stated in paragraph 10 of the reply filed by the claimant. Counsel appearing for the claimant has, however, drawn our attention to the letter dated 11/3/2020 issued by the respondent number 1 stating that Muda has an outstanding due of 2 crore 1,69,501 lakh as on that date, which has to be adjusted against the subsidy received. It appears that thereby the claimant is disputing the actual amount payable by the respondent to the claimant towards lease rental. We have heard the learned counsel appearing for the parties and also have gone through the statement made in the applications and the reply filed thereto and the connected documents. We find from the record that the respondent has also filed a counterclaim on behalf of the respondent number 1, claiming a sum of rupees 4 crore 14 lakhs 63,073 rupees 21 paise as payable towards unpaid lease rental of the dues payable from 1/10/2016 till 31/12/2022 as provided for under clause 16.17 of the agreement dated 29/11/2020. In order to prove the said counterclaim, the respondent number 1 would require to produce both oral and documentary evidence. However, since it is an admitted position that the claimant is in possession of the subject premises, and as there is a huge claim of non-payment of such dues towards rent for a long period, we deem it appropriate to direct the claimant to deposit and pay the entire admitted and contractually fixed rent of the subject premises to the respondent number 1, effective from 7/6/2022, the date of issue of notice under section 21 of the Act, to 31/10/2023, along with all government taxes and dues within 6 weeks from today, that is on or before 20/12/2023, for which a receipt shall be granted by respondent number 1. So far as the period from 1/10/2016 to 6/6/2020, however, my lord, there was a corrigendum. This has been corrected to 6/6/2022 is concerned, and which is the subject matter of the counterclaim. The claimant shall furnish a bank guarantee of an amount of rupees 2 crore in favor of respondent number 1, which shall be made valid and operative till the disposal of this arbitration proceedings. We consider this amount of 2 crore for which the bank guarantee is to be furnished is reasonable and equitable, as it is only 50% of the claimed amount of respondent number 1. In our opinion, this order would protect the interest and equity of both parties. Now, after these directions has been given, my lord, there was a corrigendum which was issued, page number 23.
Yes.
Relevant paragraph, my lord, paragraph number 3. It says, consequently, in the end of para 4, after completions of the last sentence ending with the word granted by respondent number 1, a new sentence shall be added to the extent insofar as the period from 1/11/2023 is concerned, monthly rental, measly profit for the use of the subject premises shall be paid by the claimant to the respondent number 1 of the entire admitted and contractually fixed rent for every month, which shall be continued to be paid along with all state taxes and dues in the first week of every consecutive month till the passing of the award in the instant matter, for which a receipt shall be granted for the payment received by the respondent number 1. Similarly, in paragraph 5 of the order, the date mentioned in as 6/6/2020 is typographical mistake, and the same should be read as 6/6/2022. So, after, my lord, the passing of this order, my lord, till today, my lord, they have not complied with the order of this of the tribunal, and therefore, my lord, applications was filed before the tribunal to refer the matter before the High Court, as the tribunal do not have the power for contempt, my lord, to draw contempt proceeding. And my lord, may kindly come to page number page number 9, my lord. Page number 9.
Yes.
Annexure 1. The operating, my lord, this relevant paragraph is paragraph 5, that is page number 11. It says, my lord, since this tribunal does not possess the power and jurisdiction to take action under the Contempt of Court Act, yet we feel that this matter would require strict actions and therefore the contempt proceedings to be taken up by the Honorable High Court of Meghalaya. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders for doing the needful in the matter. The matter shall be placed before the registry with this order along with all relevant documents by the counsel appearing for the respondent number 1. We may however make it clear that this order would not be in any manner construed as a fetter on the rights of the respondent number 1 to take all the other course of actions that may be available to the respondent number 1 for such non-compliance in accordance with law. And thereafter, my lord, this present contempt petitions, my lord, it has been filed by the Secretary, Urban Affairs Department, my lord, for willful disobedience of the order of the tribunal, my lord. And I would like to rely some of the judgments of the Honorable Supreme Court, my lord. Alka Chandiwar, my lord. Yes, my lord.
CC.
Paragraph 9, my lord. My lord, here.
Paragraph 9.
Yes, paragraph 9, my lord. My lord, the order passed by the tribunal to deposit the rent, it was passed by exercising power under section 17 of the Arbitration and Conciliation Act 1996, my lord. Now, my lord, paragraph 17, clause 1, it says, my lord, clause 1, subclause B, my lord, it says, a party may during the arbitral proceedings apply to the arbitral tribunal for an interim measures of protections.
You are referring to?
I'm referring to the Arbitration and Conciliation Act, my lord, 1996. No, my lord, I'm just reading this provision so that in paragraph 9 of this judgment, my lord, there is a reference. There is a reference to this provision, my lord. That's why I'm reading, my lord. It says, my lord, a party may during the arbitral proceeding apply to the arbitral tribunal for an interim measures or of protections in respect of any of the following matters, namely, my lord, only the relevant persons I'll read. There is subclause 2, securing the amount in dispute in the arbitration. Now, again it says interim injunctions or the appointment of a receiver, such other interim measures of protections as may appear to the arbitral tribunal to be just and convenient. Now, as per section 17 clause 2, my lord, it says, subject to any order passed in an appeal under section 37, any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purpose and shall be enforceable under the Code of Civil Procedure 1908 in the same manner as if it were an order of the court. So the order of the tribunal has to be treated as an order of the court, my lord, for the purpose of its enforcement. Now here, the judgment, my lord, which I am relying in paragraph 9, my lord, it says, I will just read, my lord. Pursuant to this 246th report, subsection 2 to section 17 was added by the 2017 Amendment Act so that the cumbersome procedure of an arbitral tribunal having to apply every time to the High Court for contempt of its order would no longer be necessary. This is an amendment, my lord, through which under this amendment, 2015 amendment, my lords, subclause 2 was added in section 17 of the Arbitration and Conciliation Act 1996. Now what it says, my lord, it says subsection 2 to section 17 was added by the 2015 Amendment Act so that the cumbersome procedure of an arbitral tribunal having to apply every time to the High Court for contempt of its order would no longer be necessary. Such order would now be deemed to be an order of the court for all purpose and would be enforced under the Civil Procedure Code 1908 in the same manner as if they were order of the court. Thus, we do not find Sri Rana Mukherjee's submissions to be of any substance in view of the fact that Section 17.2 was enacted for the purpose of providing a complete solution to the problem. So, my lord, earlier what had happened is, my lord, it was not, the order of the tribunal was not treated to be order of the court, and therefore every time, my lord, there is any violations of the order of the tribunal had to refer the matter to the High Court. It did not have the contempt, to draw contempt, my lord. The power was not there. Therefore, my lord, the amendment was made.
This amendment would, would grant contempt jurisdiction to the arbitral proceeding, the arbitration proceedings.
No, here what happened, my lord? Once it is treated as an order of the court, the High Court has the power, and person concerned aggrieved by it, my lord, they can immediately directly approach the High Court.
Because what you were saying earlier is that every time an order is violated or the tribunal is violated, then High Court has to take cognizance of that, or person or parties have to appear there.
Under section 27, clause 2, my lord, of the Arbitration and Conciliation Act, clause 5, my lord, if I am not wrong. 27 clause 5. It says, my lord, person failing to attend in accordance with such process or making any other default or refusing to give their evidence or guilty of any contempt to the arbitral tribunal during the conduct of the proceedings shall be subject to the like disadvantage, penalties and punishment by the order of the court on the representation of the tribunal as they would incur for the like offences in suits tried before the court, my lord.
Yes.
Now, as a result, my lord, as per this order of the Honorable Supreme Court, now the order of the tribunal has to be treated as a order of the court, and party can directly approach the High Court for any violation, my lord, because it has to be treated as order of the court. And therefore, my lord, what the plea was taken by the contemner here, my lord, if my lord will come to the affidavit filed by the contemner, regarding maintainability, they have raised the issue of maintainability of the present application, my lord.
Yes.
It says, my lord, paragraph 6, I will read out, my lord, that the answering respondent further submits that the arbitral tribunal having referred the matter to this court. Paragraph 6, my lord.
This one. Para 6.
Paragraph 6, my lord.
Yes.
It says, my lord, that the answering respondent further submits that the learned arbitral tribunal, having referred the matter to this honorable court, and the decisions thereof being still pending on the reference, there was no occasion for the petitioner to file simultaneous contempt applications, especially when the said reference was at their instance. There cannot be two parallel proceedings in respect of the same cause of actions, and the reference being at that prior point of time, and the decisions to the said reference being still under consideration, the instant application does not merit interference at this stage. Paragraph 7, it says, my lord, that furthermore the answering respondent states that though an applications under section 27(5) of the Arbitration and Conciliation Act 1996 appears to have been preferred by the petitioner before the learned arbitral tribunal, no order indicating approval or grant of such approval has been annexed by the petitioner in the instant case, which only establishes the inadequate compliance of section 27 of the Act, more so when the reference by the learned arbitral tribunal is pending considerations and there has been no order in that regard by the honorable court till date. It is stated that there is already a reference pending for considerations of the honorable Chief Justice, and until decisions in this regard is taken on the reference so made, there was no requirement on the part of the petitioner to file these instant applications, leading to multiplicity of proceedings. Here, my lord, even the order of the tribunal, my lord, it made it very clear at page number 12, the order which was violated by the contempt, my lord, page number 12.
Yes.
The last relevant portion of the paragraph, it says, my lord, we may however make it clear that this order would not be in any manner construed as a fetter on the rights of the respondent number 1 to take all other course of actions that may be available to the respondent number 1 for such non-compliance in accordance with law. So petitioner is, my lord, free to come before this court and file an application for contempt against the order which was passed by the tribunal, my lord. So, and my lord, I have also referred to one of the judgments.
See, Mr. Sinkon,
my lord,
if I understand correctly, there is an apparent violation of the order of the arbitral tribunal.
My lord.
We agree by that. You have, preferred. I mean, first you have approached the tribunal for contempt. Tribunal said we don't have power of contempt. Matter to be referred to High Court.
We filed an application under section 27(5)
so,
to refer the matter, my lord.
Okay. To refer the matter.
Yes.
That was your.
My lord.
So see, subsequently the matter was referred. The matter was referred to this High Court. If I know you are aware of that, or the records would say that the Honorable Chief Justice has passed necessary orders. He has passed necessary orders in that regard.
Here,
for taking of the reference. Now, simultaneously, you have also filed another application.
Yes.
So your purpose is for the contempt to be taken up.
Or yes, my lord. Contempt has to be
one way or the other.
Right, my lord. Either this way or that way, my lord.
So
proceed.
Why would? Oh, okay.
This
That
should not come.
But it is their objection as far as maintainability is concerned.
Right, my lord.
Even if suppose now we have not yet heard them. Even if we decide that your application is this instant application is not maintainable,
my lord,
the order of the tribunal would still stand.
Still stand.
The procedure would still be carried out.
Carried out.
It may have been carried out.
Right.
For all intents and purposes.
Yes.
So eventually the contempt proceeding would be taken up by the competent court of jurisdiction.
Right, my lord.
Where's the issue of maintainability here?
That is the that.
What do you see? This reference was already taken note of by this court. That reference was already taken note of by this court.
Yes, my lord. And in the order also, my lord.
Just a moment.
My lord, if I may, my lord, in fact, there was no reference, my lord, because they have filed this application under section 12.
Just a moment, just a moment. If I may be wrong, we'll just check the order sheet. If I remember correctly, this court has passed an order in that regard. Just a moment. Forcing? No.
Your lordship can refer to order dated 4/7/24. Lordship, that would clarify, lordship.
Exactly. No, this is the reference. See, the arbitral tribunal has referred the matter to the registry to be placed before the Chief Justice.
My lord.
So it must have been placed.
Yes, and in this page number 12, my lord, it also says the respondent counsel, my lord.
True.
Yes.
But why would you see if one let's put one course of action
My lord.
suits you,
Yes.
or serve the purpose,
Right.
why would you resort to another course of action? But yeah, this is the reference. Order? Yes. See, that same order, same order. It says place this matter before the Honorable Chief Justice. So matter must have been placed before the Chief Justice.
Lordship, this is the same application, lordship.
Yes.
What happened to that reference? Where is that reference?
Lordship, lordship, if I may,
Mr. Sinkan, what the reference which was made by the arbitrator, what happened to that?
My lord, may kindly see the page number 12. Page number 12, the order of reference.
Lordship, that is only an order. What has
My lord,
happened?
may kindly see.
Lordship.
Page number 12.
Number 12 means that there was an order by the
Lordship.
arbitration
Tribunal, lordship.
and to referring the matter.
The
Now,
secretariat, lordship, of the.
see, if you see the order sheet of this, when it was pending before single judge, the learned single judge has taken note of the fact of that order of the arbitration tribunal.
Right.
And they referred this instant matter. This matter means the matter which you have filed.
Right.
To the Honorable Chief Justice, and therefore subsequently it came up. Now this court wants to know what happened to that reference.
My lord,
Reference which was made by the arbitration tribunal.
My lord, subsequent to that, my lord, if any order is separate order is passed.
Lordship, that is still pending with the.
Now, my lord, may
arbitral
kindly
tribunal, lordship,
see.
in my humble submission.
No, this is the reference.
Lordship.
The question of pendency doesn't arise. The court has been referred from there.
Yes.
Where is the question of pending it there? It cannot be pending before the arbitration tribunal.
What we can do is, I don't know if that is proper or not.
Lordship, what has happened is during the pendency of the matter, lordship, the term of the arbitral tribunal.
The arbitral tribunal, my lord, in the order dated 8/11, my lord.
Just hold on.
Lordship.
this is. See, Mr. Sinkon,
My lord.
you or rather both parties, just tell us what is the form and substance of a reference to be made before the Chief Justice. That is in reference to section 11, isn't it?
My lord.
Not section 11, sorry. Now, the body of the order in question is to be placed before the Chief Justice with maybe with a forwarding note or letter or whatever. And on the body of that, the Chief Justice would pass an order.
My lord.
Isn't it? I am not so sure.
My
But
lord,
that is the form and format of
my
how
lord,
a reference is to be
in fact, the
dealt with.
Honorable Tribunal, my lord, in his order dated 19/2/2024, that is paragraph number 5, that is the last paragraph, if I can read, they have given specific direction to the respondent number 1 also to place all the record before my lord. May kindly see if I can read this paragraph, my lord. Since page number 11. This one.
Page number 11.
11, my lord. Paragraph 5.
Yes.
It says, my lord, since this tribunal does not possess the power and jurisdiction to take action under the Contempt of Court Act, yet we feel that this matter would require a strict actions, and therefore the contempt proceeding to be taken up by the Honorable High Court of Meghalaya. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary order for doing the needful in the matter. The matter shall be placed before the registry with this order along with all other relevant documents by the counsel appearing for the respondent number 1.
See, to this we understand.
Yes.
See,
By
we
this
understand.
contempt application, my lord.
By this order, the matter was referred to the High Court.
My lord.
To be placed before the registry, and then, and then finally,
Chief Justice was supposed to pass an order, my lord, as per this.
How is that process? You see, how is that process initiated?
Lordship, the answer, Lordship will find the answer in Lordship Contempt of Courts, Lordship High Court of Meghalaya Rules 2013, Lordship. It's at page 185, Lordship, Rule 5, sub clause 1.
Page
185, Lordship.
No, it's there.
Rule number?
Rule 5, Lordship.
Rule 5.
Rule 5, Lordship. If I may read, Lordship.
Yes.
Every reference relating to contempt of court subordinate to the High Court shall be scrutinized by the Registrar General, who shall place the same before the Chief Justice or any other judge nominated by him in this behalf for obtaining orders after noting thereon the nature of the contempt. Subclause 2. When any publication, application letter or intimation is received by post or otherwise call for any action being taken under the Act by the High Court.
This is not relevant.
Lordship. 5.1 is the relevant, Lordship.
5.1, yes.
Lordship. So, Lordship, there has to be a reference, Lordship, by the subordinate court, Lordship. In this case, Lordship, it would be the Secretariat of the Arbitral Tribunal, Lordship, who ought to have made the reference, Lordship. Thereafter, it was to be placed before the registry, who then, Lordship, has to place it before the Chief Justice, Lordship. In the instant case, nothing has been done, Lordship.
Subclause 2 of the same section, my lord. Same rule 5, subclause 2, my lord, it says, when any publications, applications, letter of intimation is received by post or otherwise, call for any action being taken under the Act by the High Court on its own motion, the matter shall be dealt with in the manner prescribed in Subrule 1. In the case of criminal contempt of a subordinate court, the Chief Justice or the judge, as the case may be, may direct that the papers be sent to the Advocate General of the state. But that is for criminal contempt.
No.
Now, as soon as, my lord, that order was placed before the Honorable Chief Justice, my lord, And in the same order of the tribunal, it has also made it has been made clear by the tribunal that the respondent number 1, the petitioner herein, my lord, he can, my lord, take all other course of action that may be available to the respondent number 1, and there is no doubt that this court.
You see, if I understand correctly, that part of the order cannot be, cannot be taken to be a continuation of the earlier part, because what the second part says is you are allowed to take any other course of action in suppose we are not saying including execution. So that does not have anything to do with contempt proceedings.
That includes even contempt also, my lord.
Lordship, in that case, Lordship,
why I am saying
my
so, my
learned
lord?
senior friend is saying there has been a reference at the same time.
Now-
My learned senior
Now, my lord, may
senior friend
kindly
is saying,
see,
Lordship, he has the
but
remedy.
there
to-
is no contempt proceeding that has been drawn on the basis of the reference by the Chief Justice as on today. And I am free, my lord, even the Honorable Supreme Court says the order of the tribunal has to be treated as an order of the court. And any violations, I can, being a petitioner, my lord, I can approach the High Court, and there is no doubt that this court possesses the power of to take action for any contempt of the order, my lord.
See, we are in a peak situation where, firstly, as Mr. Chanda has said, we don't know whether the registry of the arbitral tribunal has referred the matter by way of communication to High Court. There's no indication. The only thing we will say is this: that has come to the notice of the Chief Justice is by an order of this court.
Yes.
Directing the matter to be placed before the
Chief Justice.
So we don't know whether that can be constituted or taken as a reference.
Now,
there is no
as
precedent.
far as reference is concerned, the matter, the order of the tribunal has been placed before the Chief Justice, my lord. That is the direction, and it has been placed. And now, once it has been placed, the Honorable Chief Justice was supposed to pass an order taking up the contempt proceeding. In this case, my lord, there was no contempt proceeding that has been drawn suo motu on the basis of the reference. Now, I being the petitioner, my lord, because of the violation, I am always
Lordship,
free
that will
to come
amount
before
to
this
parallel
court, my lord.
proceeding, Lordship, if I may submit.
Who's to do that? Respondent.
Lord, law does not bar me to approach the
See,
court
my
for
brothers,
violation.
my brothers rightly pointed out. You see, in fact, if you go to that impugn order, no, not the order in question, that paragraph 5, see, page 12. See, it says, the matter shall be placed before the registry with this order, that means registry of the High Court, along with all other relevant documents by the counsel appearing for the respondent number 1.
I have placed by way of this petition, my lord, all the documents.
This is, Lordship,
All
in my
the
humble
documents.
submission is a section 12 petition. Lordship,
Even otherwise, my
the
lord,
contempt application says otherwise, Lordship.
You
The
see,
contempt,
this is not the way. No, I don't think what you should have done is you should have placed all the matters, as was directed, place it before the
registry.
Chief Justice through the registry, and the registry will take the necessary steps. But instead, you have filed, an application.
My lord, there may be a fault on my part because I have.
that direction.
Yes.
If you wanted to approach this court, you could have approached this court directly. There was no need for you going to arbitration tribunal and obtaining order of reference. once you go there, approach this court, an arbitral tribunal pass some judgment, pass some order, is it not binding on you?
My lord, one way it is, but
Just say, is it not binding on you? Now, if it is binding on you, the action which was required to be taken up by you was that you should have placed all the material before the registry in terms of this order.
Yes, my lord. Yes, as per the directions, my lord, I should have placed before the registry. Yes. Now
you do not do it. You bypass.
I have filed. Yes.
Instead,
yes.
Short circuit the process. Okay, and then you file dialect application, isn't it? Under contempt of court.
Right, my lord. And where now, my lord, as far as this application is concerned, my lord, there is no bar.
Mr. Snukon, to cut the matter short, we will dismiss your petition as not maintainable, allow you to comply with the orders of the tribunal. Perhaps we can condone delay if any. That's all.
I may require, my lord, further instruction. However, my lord, my submission is, my lord, because of the order dated 19, my lord, that is 19/2/2024, that matter is referred by the tribunal before the Chief Justice. And my lord, this order I can comply even tomorrow. But however, because of this order, my lord, I am not barred under law that I cannot approach this court under section 12, my lord. Their challenges, my lord, as regard to my application.
We are not saying you are entitled to.
Yes.
But the fact is that again, as I've said at the outset, you have come, in a two-pronged manner. See, firstly, you have gone before the tribunal, and then when the order was passed, instead of referring the matter as was directed, you came before the court. You could have done that as my brother
that
said.
Procedural flow, my lord. That will not.
Anyway,
yes.
We are not on that. We are
yes.
not on that. See,
now,
we are not shutting you out.
Yes.
See, you have a case. We are not shutting you out.
Now, my only contention is, my lord, the submissions which my learned friend has made, that this application is not maintainable, my lord, it is totally wrong. There is no bar in the law, my lord, that I cannot file section 12 applications before this court, my lord. And if there is no bar, my petition is very much maintainable, my lord.
Except for the fact that you should have complied with the direction given by the tribunal.
Right.
Otherwise, there is no bar.
There is no bar. When there is no main.
Now, if that has not been complied with, you have come by way of another format, so to say. That will not do. You're saying something, sorry.
The same thing I was trying to say it in different. You see, the thing is that it is you who approach the arbitral tribunal.
Right.
So far as your right to approach this court now stands diluted because of the passing of this order. This order was obtained by you, isn't it?
Right.
So you have to follow that. Now, if you say that this order will not bind you to follow the process.
No, I'm not saying, my lord. What I'm saying, there is no bar.
You say that what your submission is that the substance of your submission is that even if this order remains, your right to approach this court does not stand interfered.
Yes, my lord.
But then the directions in that order gives us a different meaning. It says that it is you who have to place all the materials before the Registrar General, and you have the liberty to take all other course of action.
Yes.
That is a different thing. My lord has already
in my interpretation, my lord,
that may include execution proceeding or whatever.
Even arbitration, even contempt application, my lord.
That is what you are saying. But then what happens to this order then? Now, if you go by your thing, then what happens to this order?
Now, in another scenario, my lord, if suppose the reference has been made to the Chief Justice of Honorable Chief Justice, my lord, and
let us see. Let us not go into all those things. You may even this petition may be maintainable in spite of the reference.
Right.
But then tell us what happens to that order passed by the arbitration tribunal.
That is the scenario I want to say, my lord. If what happens in circumstances when Honorable Chief Justice does not take up the sumoto contempt proceeding.
It has not been placed. It is not placed before
now
the court.
here.
So why should we assume that situation?
Now here, my lord, what the order says, my lord, we therefore refer the matter to the registry of the Honorable High Court of Meghalaya. Who is referring? The tribunal itself, my lord, for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders for doing the needful in the matter. The matter shall be placed before the registry with this order along with all other relevant documents by the counsel appearing for the respondent number 1.
That is you.
Yes.
Then?
Now, my lord, even the order it says that it will be referred by the to the registry by the
You are going back to the same thing again and again. See, you have candidly admitted that there was some flaw in your approach, see, by not complying with it. So how to overcome that? See,
Now, my lord,
how to overcome that?
I do not
that should
think,
be
my
your
lord,
endeavor before this court.
ultimately, my lord, because of that procedural flaw, whether I place it through the record or I place it before the Chief Justice by application, that is the process. However, the end of the matter is, my lord, whether that matter whether all the relevant documents has been placed before this court or not. That is the relevant question. Whether there has been any violation of the order of the tribunal, my lord. Ultimately, that has to be decided, my lord. Now, without going into the merit of the case, my lord, they are trying to divert, saying that this application is not maintained.
Directing you,
yes,
to follow that procedure would definitely lead us to same situation.
Same situations, my lord.
That is definitely one of the aspects.
Yes.
But then in such a case, we have to ignore the order passed by the
tribunal, my lord. Yes.
Now, the again question comes. We do not know jurisdiction of a division bench in a criminal matter.
This is criminal contempt or
Lordship, in my humble civil contempt.
Now, whether do we have jurisdiction to do that? If we had to go by your thing, because we can understand this matter was placed before the Honorable Chief Justice just on the basis of submission that there is a reference by the arbitrator. Now, the placement of the matter is only on the basis of that. Now, is it not that if it is to be taken up by a division bench, then there may be certain formalities which require to be followed?
He has just referred to this bench. Very much. Contempt rules is I have them. Yeah, just move. Let me just get. See. Unless we'll see. Okay, so we'll hear you, Mr. Sanda.
Lordship may
today.
Lordship may have it next week. Lordship, Leonard Sunil will be here. Lordship,
Mr. Ensign Leonard GA, appearing for the petitioner, state petitioner, Mr. and the learned counsel for the contender. Respondent has sought for some time to respond to the said argument. Accordingly, as wait for this matter to 1 week.
Item number 11.
My lord, this is part heard matter. It has been heard on 12th of March.
What is this matter about?
Your Lordship, here I'm challenging the order and judgment of the trial court, Your Lordship, wherein I was convicted for 10 years under section 5 and 6 of the POCSO Act.
Where is the
It is for the state to reply on, Your Lordship.
State?
Yes, Your Lordship.
We'll post it to next week then.
Oh, yes, Your Lordship.
None appears for the state respondent after. Miss, your legal aid counsel?
Yes, Your Lordship.
And legal aid counsel has appeared on behalf of the appellant and has submitted that the argument, as far as the appellant is concerned, is concluded, has been concluded. The state respondent is to respond to the same. Accordingly, list this matter to 1 week.
Oblige, Your Lordship.
Item number 13.
Lordship, in this matter, we are like newly engaged, Lordship, in this matter. So we are praying for.
You file your power?
Lordship, give us 2 days. 2 days.
Have you
time.
filed your power?
No, Lordship. You 2 days time, Lordship. We give any Lordship will be filing. Lordship.
Mr. Learned Counsel has submitted that he has been recently engaged by the appellant in this matter and has not yet filed the power. It is prayed that some time may be allowed for the power to be filed. As prayed for, this is matter to 2 weeks. God bless. Single bench will sit up for 10 minutes.
Not for the time for the response. May I
Yes.
please your lordship, with regard to the prayer, if your lordship is pleased to see the prayer, my contention this has become infructuous. There is nothing substance.
No, I think the court has posted this matter today to get the response.
Lordship.
As to whether, the whole, it may be, that is your contention.
Yes.
That it has become infructuous. They may say otherwise. So it would be, whether it be proper for the petition as to be taken up on merits and heard and to be heard. With your, the affidavit which your affidavit, you see the affidavit that you have sought to be withdrawn, that
Yes.
will be on record. So in the meantime, since the whole, the petition is to be,
It doesn't survive at all.
so it will come in due course.
Yes.
Once the matter is heard, that issue will also be taken up.
Yes.
What do you say? Yes, Miss, what is your instructions?
Lordships, we have prepared a synopsis of our objections to the miss case that was filed recently.
We are not talking about, we are not, see, as far as the miss case is concerned,
Lordship.
you were there. when the
Lordship.
matter was taken up. What this court has, has requested the parties is for the matter to be taken up, the whole petition
Lordship.
to be taken up for hearing.
Lordship.
Without, disposing of the
Lordship.
the application filed by Mr. Mahanta.
Lordship.
That will be on record in
Yes.
due course.
Lordship.
If the issue of,
If the whole case goes, that automatically goes. That's right.
Lordship. Lordship, I concede to Lordship's view, Lordship.
So we'll take up the matter for hearing then.
Lordship may have this matter next week, Lordship.
We can have it any day.
Lordship.
It's up to you. But since you have filed, let it be on record.
Lordship.
Copy.
It has not been processed.
Lordship, this would be a synopsis of our
synopsis.
objections, Lordship. Essentially, the same arguments, Lordship.
Why two? Same.
2 copies, Lordship. 2 copies, Lordship.
2 copies not necessary.
2 copies of the same synopsis of objections. Lordship.
Why give 2 copies?
Lordship, we may.
So, Mr. Mahanta, you're clear on that?
Yes. Let it be on record, the objection. And if I can succeed that no cause of action subsists, then it will go everything.
Heard Mr. S.P. Mahanta, Leonard, Senior Counsel, appearing for respondent number
6.
who has submitted that the said respondent has referred a misapplication being this case number 75, nay.
Lordship, 80. 75, Lordship, 75 was withdrawn. 81 is the...
81.
81, Lordship.
This case number 81 of 2025. No. However, at this juncture, the Leonard Senior Counsel has submitted that the said respondent would not press for hearing of the said misapplication and would prefer that the entire writ petition be heard on merits. That's it. Ms. Learned Counsel for the petitioner has no objection to the submission made and has submitted that the merits of the writ petition may be heard, for which some time is paid for. Yes, Mr. Shulai,
Lordship, so far that
you have anything to say as far as hearing of the petition is concerned?
Main petition.
the main petition.
That is
That's what I mean to say.
That is why, if you see, if we remains to be seen, what they have to say. If that is so, then as contended by Mr. Mahanta, even his application will have no bearing.
No bearing.
But and we'll see. So therefore the petition will be heard then. The main petition will be heard.
Yes, main petition.
The other respondents, the learned counsel for the other respondents, the respective counsel for the other respondents has also no objection for the main petition to be heard and finally disposed of.
Much
obliged. This is matter of the 2 weeks.
On the release item number 1.
Please, Your Lordship, can you grant us 2 weeks' time, Your Lordship, to file the affidavit, Your Lordship?
Your correspondent number?
125, Your Lordship. GHDC.
How many times have you sought for adjournment? Why?
So the draft is ready. It's just a matter the issues and the signature, Your Lordship.
Miss Learned Counsel for the respondent number 125 has yet again sought for time to file the counter affidavit on the same ground as was indicated in this court's order dated 13/5/2025. You have any objection?
No objection.
Since Mr. M.L. Longpure, Learned Counsel for the petitioner, has no objection to the same, the prayers along. Mr. Learned Counsel for the respondent 6 has also sought for some more time to file the counter. Let this said counter affidavit be filed within the next date fix. This is matter of 2
weeks.
2 weeks.
Tell you obliged, Your Lordship.
Item number 2.
The written argument, I'll file it today.
Mr. P. Procedural, Learned Counsel for the LRG has submitted that written argument has been filed on behalf of the respondent number 124. Then appears for the respondent number 5. Oh, you're there. Are you also filing your written argument? I think that has been noted somewhere. Mr. Learned Counsel for the respondent number 5 has once again reiterated that the respondent number 5 is just a formal party and has no stake in these proceedings. Accordingly, no argument would be advanced from this respondent's side. Accordingly, this matter is now reserved for judgment.
Obliged.
Item number 3.
May it please, Your Lordship. Lordship, as per the last order of this Honourable Court, Your Lordship, we were directed to prepare informal paper book. Lordship, the same has been complied with, and we have already served a copy.
I have not even gone through the whole paperwork. I've just flipped the page, and what do I see? Apni, look at your annexures. If you can read it, I'll give you 100 marks.
Your Lordship, some.
You see, if there are, documents or any communication that are ineligible, I mean, you should have made an endeavor to get it typed. And the process is annex the type copy. You're filing in that way. How can, if I'm not, like I said, I'm not saying anything. But if that particular document comes in into focus at the hearing, then what do I do?
We'll get it typed.
Please, be careful. In this is the High Court. You cannot just.
My apologies.
Like they used to say, this is not a Mufassil court. You know what is a Mufassil court?
Your Lordship will.
Mr. Padia will know. You're from Bihar?
Yes, Lordship.
So you will know. Mr. Counsel for the President has submitted that the paperwork could not be prepared today and has sought for some time for the same to be filed. 1 week?
1 week time, matter may come after 2 weeks, Your Lordship. In the meantime, I'll prepare a type copy and I'll serve them the type copy of those relevant pages.
Submitted that the said paperwork may be allowed to be filed within the next date fix, for which an advance copy will be handed over to the counsel for the respondent. Accordingly, as prayed for, this is matter of 2 weeks.
2 weeks. Obliged, Lordship.